As that they will go to, there are certain things that they will go to their graves with. They wouldn't talk about them. Professor Kweku Azar says that the discontinuation of prosecution raises important questions about governance, the rule of law, and the fight against corruption. Beyond politics, we must examine the legal and procedural realities that shaped these cases. Each case has been in court for at least 7 years. If prosecutions fail despite claims of judicial favorability, we must ask, were they rushed? Was the evidence weak? Were the charges politically motivated? Justice is not served by endless trials without conviction. Instead of debating the discontinuation, we should ask, how do we ensure prosecutions are based on solid legal grounds? What lessons can improve future prosecutions? How do we prevent justice from being weaponized for political battles? The focus must be on systemic reforms, ensuring stronger prosecutions, better case management, and a legal system that delivers fair, timely, and credible outcomes. Justice demands accountability, but it must also be efficient and fair. We'll be right back to ask this very question on the back of the various processes that have been put in, leading to the acquittals that we have seen, Opuni and Agongo. Their case has been going on for almost 8 years. They have been set free, so to speak, acquitted and discharged. Samuel Ofosu-Ampofo was under prosecution for conspiracy to cause harm. Together with Johnson Esiama, also had his own, situation he was facing. They've been acquitted. He, I think a day or two after his acquittal, he just got his job at the Bank of Ghana back. We'll be right back. You're welcome back. And the Attorney General, Dominic Ayine, has been busy in the courts doing a few things. His first his first instructions have been to go to the courts and discontinue all cases against some NDC or NDC affiliated persons. And as you are aware, Atuforsen Richard Jakpa, Atuforsen Minister for Finance Richard Jakpa, a businessman, of course, they got their liberty through the courts, but the Attorney General went on an appeal against them. So that's being dealt with as, call it like a civil process. The Attorney General has gone to the court to discontinue that case, so it's gone. Dr. Stephen Opuni, former Cocoa Board CEO, he was standing trial together with Seydou Agongo. There was a withdrawal put in, a process in law called withdrawal was put in, and they were not only discharged. Some people are surprised about it. Why is it that they were not just discharged so that they can be put on any time, but they've been discharged, acquitted and discharged? How did that happen? Chairman, former national chairman of the NDC, Ofosu-Ampofo, he was standing trial with, what's his name? Is it Boaheng? Okay, so that one too, they have put in a withdrawal and they are free, they are gone. Johnson Esiama, former deputy governor of the Bank of Ghana, of course, he's returning to his role after the government or the state put in the withdrawal for him. So all of them have gained their liberty and they are free. Stephen Opuni, for example, says that, quote, "The living God I serve has disgraced, cursed all my enemies, my prosecutors, and destiny haters," end quotes. I'll come to you before I go to Nana Atodazi. First, tell us, what kind of law allows this, that you are going through prosecution and then in the middle of the prosecution, you are completely set free and the prosecution is botched, terminated?
Well, the prosecutions are done in the name of the Republic. So it is the Republic that has the discretion whether to prosecute somebody or not. That power to prosecute is vested by virtue of the Constitution in the Attorney General or any person that the Attorney General may, by any law, delegate that power. I think if you look at the Criminal Procedure Code, it provides that the Attorney General may enter nolle prosequi at any stage of a criminal proceedings before judgment is delivered.
That's different from withdrawal.
Yes. If the Attorney General enters nolle prosequi, it only results in a discharge. What it means is that the person is not acquitted. The person can be arrested and put back on trial for the same charge. The Attorney General need not give any reasons for that exercise of the nolle prosequi. So in this instance, if the Attorney General had entered nolle prosequi, it means that the prosecutions, whatever stage they would have reached, would only have been withdrawn or stopped, and in the future, it could be recommenced. Now here, the other means by which the state, acting through the Attorney General or the Attorney General's office or the prosecutors, can exercise this power of prosecution is by doing what is called the withdrawal. And the withdrawal has different consequences depending on the stage that the case has reached.
Okay.
If it is exercised before the close of the case of the Republic, it means that it can only result in a discharge. What it means is that the person who the state has entered the withdrawal notice can be rearrested and tried for the same offense.
That is when the state has not concluded its case.
They've not presented all the evidence in the course of it before they say, I'm done with my case. They can exercise the withdrawal. Normally, it's done to restructure if they think that there's some evidence they've not brought.
Okay.
But if it is after the state has closed their case, and whether or not the defendant or the accused person, in this instance, has opened his defense, if the state decides to exercise that right of withdrawal instead of nolle prosequi, then it means that the accused person is not only discharged, but is acquitted and discharged. What it means is that the accused person cannot be rearrested and tried for the same offense. Because the notion is that once you have presented as a state all your case, you have put everything before the court. The accused person had an opportunity to do everything, prepare his defense, because the Constitution says that you will not do anything that would disable an accused person from being able to provide his defense in the matter. So if the state, you have closed your case, you've given the accused person the structure of your case, they are now allowed to exercise their right under the Constitution to open the defense. The moment you say that, no, you are withdrawing it, you should not be allowed to go and restructure your case. So once you exercise that right of withdrawal as the Republic, after you've closed your case, then the accused person will be discharged and then acquitted.
All right.
So you cannot rearrest him and bring him back to face trials or charges.
So as far as these charges against all these individuals are concerned, that is except Atufosing and Richard Japa, which was just an appeal, it's case closed forever.
Done.
Yes.
Interesting. So this was a skillful way to go about it. Why they didn't go for a nolle prosequi, which meant that it could be reactivated in future. And join me tomorrow, 2 p.m. on the law. I'll be with him, Bobby Banson, and we'll give you the education info. And after that, there are those who are saying some of these cases, it appears that the accused persons had a good case. Yeah. At least that's why it has dragged all these years and the Republic couldn't finish their case. So why don't you rather allow it to go to the end on its merit rather than truncating it so that they get their freedom and know in their heart of hearts that they did this and won?
Well, that's a good question, but the reality is that the realm of prosecution lies with the Attorney General. And the Attorney General under Article 88.3 has a power to initiate and ensure the conduct of a trial. Of course, that means he has a power to start, he has a power to stop, he has a power to withdraw, he has, all that. So, like what Bobby said, Article 88.3 does not provide for any reason even to be given whatsoever. So if it's the man who started the thing says, I'm taking it back, I'm withdrawing, we can't even go beyond to find out the reasons why, he's saying that. They may have good reasons. Maybe he sees that upon studying the docket, this is a hollow docket. He sees that this is a wholly political thing. Maybe it's slanderous something. I was tried after we left government under the Abrupt Rights Project. And up to today, I've refused to read the judgment, the whole judgment, And you know why? Because I just didn't understand why I should be in the court in the first place. And I knew the reason. Some told us that we were making too much noise, so they keep them busy, whatnot, So there could be all kinds of political, funny reasons given. You understand? I think that at a point in time, in the new dispensation, you take opportunities. Why has this case dragged for 7 years, 8 years? If there was something in it, they would have convicted them long ago, And let's create a new, atmosphere. Let's have a new slate, the slate clean, and then let's see. But clearly, these people have disputed. They've said, look, we didn't do what you charged us with. Produce evidence. And that burden...
They are mounting their defense as we speak before the truncation because the court took the view that they have a case to answer.
Yes.
Otherwise, they will not be mounting their defense. After prosecution finished their case, they filed submission of no case. Yeah. The court would have acquitted and let them go. But the court didn't.
But sure, submission of no case is just a scintilla of evidence. It's enough to keep you in the trial. Mm-hmm. You understand? Mm-hmm. Scintilla of evidence. The tiniest, you were there at the time. It's enough.
The scintilla of evidence also is all that is required to... But like in our trial, Justice Alfred, you people come and stand and say something. It was openly, So I think that there is really the law permits it. Two, the length of time. I think is it, Mr. Azar? Yes, Kuku Azar.
It is a fantastic summation of summary of the legal political situation. We must keep faith with our system, a judicial system that permits a case to run 8 years. There are people in prison.
These are cases that the people involved, because of the stakes and the fact that they can also afford, they are appealing every single point of law. They will go to Court of Appeal, go to Supreme Court. So that's part of why it dragged.
They are entitled. Unfortunately, there are people who are who are in the prisons at Nsawam. 10 years and whatnot, their cases have not been called. It is out of this, that the system is not working well.
Right.
That's why we had a position of taking justice into the prisons.
Our time is exhausted. Let me go and see if I'll get a minute's comment each from our guests on Zoom. My outfit, as always, is by Kunati Clothing. You can call them 0244 676732. Find them at the Adenta Shopping Mall. And we have been starting at 8 a.m. And we're doing that, hoping that the transition will be over quickly. Then we'll revert to our 9 o'clock. So hopefully, we are hoping that by the close of next week, the ministerial things would have been over. Then we'll revert to the status quo ante, 9 o'clock. Yes, so let's hear from Rhoda and Mary. If you can spare a minute each to summarize your thoughts on these acquittals.
Yes, Samson, quickly. I think clearly the lawyers have established that there's basis for the Attorney General to engage in such acts. And I think for me, the question I'm asking is, in the case of these individuals, what would be the basis? What were the reasons for that? It would have been good if we had an idea of why these cases were being terminated. Of course, I'm not sure these are not the first cases to be terminated. In some cases, we've read about reasons have been provided. It would have been great if we had an idea of why these cases, especially in some of them, there are other individuals who are also involved, but some individuals, the case has been terminated for some individuals. And that's where I have an issue with. Maybe it's something with the law that we can look at to see so that we can clear every doubt, especially in one instance where somebody is stepping into a very key position as the governor of the Bank of Ghana. Would it be in the interest of the person to go through the process for the person's name to be cleared if indeed there's nothing really that the state had against such a person versus terminating issues at this point?
Right. Let's hear Mary. And unfortunately, they don't give reason because the law says they are not bound to give reason. And I am one also championing that. I'm waiting for one of them to happen. If it doesn't happen, I'll have a problem with the Attorney General. That coup that was said to have been staged on Facebook, Oliver Barker-Vormawor, they should go and terminate that case. Mm-hmm. Yes. Yes, Mary, quickly, what are your thoughts? Hello, Mary? Oh, no. Mary cannot hear us. That's unfortunate. Our time has also run out. Thank you also very much for tuning in and watching Newsfile. I have just received your messages, quite a good number of them. Unfortunately, I couldn't read them. I promise you that next time I'll be reading your messages and read them religiously for you. Thank you very much, Nana Atodazi. He is international political transition expert and senior lawyer. Bobby Banson is private legal practitioner. He teaches the law at the Ghana School of Law. Mary Awalana Ada is executive director of the Ghana Integrity Initiative. And Rhoda Osei Afo is senior research analyst, Ghana Center for Democratic Development, CDD. Earlier, we spoke to Erastus Asare Donko, and we also were joined by Alhaji Habib Idrisu, MP Tolong, and First Deputy Minority Chief Whip. Have a good afternoon. I'm Samson Ladi Anyanini.